One thing I want to go back and talk about on from the outline on courts and alternative dispute resolution, and that is the idea of standing. So standing is a little bit like jurisdiction. Jurisdiction, if you remember, was the power of the court to hear a case, the power of a court over the subject matter and of the people or parties before it. Standing is refers to the fact that parties in a lawsuit have to be interested parties, or else they don't have standing to be a part of it. They have to either have suffered some wrong or be potentially subject to suffering some sort of wrong. So, for example, Mr. Henry cannot sue me for divorce on behalf of my wife. He has no standing in that. He has no interest in it. It doesn't harm him. It doesn't affect him in any way. If I own a house, if my wife and I own a house with Mr. Henry and we're getting divorced and the court is going to divide up our assets, which would include the house we own with Mr. Henry, he might have standing to enter that case, not to ask the court to divorce us, but to protect his own interest in that house during our litigation. You have to have some sort of standing to sue. If the city of Columbus wants to build a landfill or a toxic waste dump in some property behind my neighborhood, and I want to sue to stop that, I've got standing for that. I'm somebody who could be affected by that. If my brother in North Georgia wants to sue the city of Columbus to prevent that, he might not have standing. Can anybody think of an argument he could make that he has standing? I mean, it's a stretch, but something like, well, I'm a citizen of the earth. I use nature. I go out in nature all the time. A landfill or toxic waste dump is going to infect the environment, and it's not my backyard, but I'm a citizen of the world. It's going to affect the environment in Georgia. I live here. It's a stretch, but Mike could make that argument. So standing. I didn't mean to skip that on Tuesday, but somehow I did. So let's move now to the case of Arrow Toy Store versus Greaves. So this case illustrates a lot of things. I like this case at this point in the semester because I think it pulls together some things we've been talking about the first 2 weeks and kind of shows you an application of it. So Arrow Toy Store versus Greaves. Let's start out with the basics. Who is the plaintiff in this case? It's a little bit tricky. Greaves is the plaintiff, that's right. He's the one that brought the lawsuit. Who is the defendant in the case? Toy Store, right. Arrow is the defendant in the case. So Greaves sued Arrow. Where did he sue him, Mr. Hare? What location? Georgia, good. Did he sue him in the Georgia court state system or the federal state system? Federal court system, sorry. That made no sense. Are we in the federal court system or the state court system? State court system, right. How do we know that? Look, the name of the court, well, right, he brought it in the state court of Cobb County, which was the trial court, so that's exactly right. Also, this opinion was written by what court? Court of Appeals of Georgia, right. So we're in the state court system. The opinion that you read, is that from a trial court or an appellate court? From an appellate court. Remember, this is an appeal. Trial courts are your entry-level courts. That's where the evidence is given, testimony is given, witnesses are cross-examined, and a decision is made by a judge or a jury. Appellate courts are the next level up where if someone either loses or has a ruling go against them in the trial court, then they can appeal that to an appellate court. This is an appellate court that wrote this opinion. All right, so Mr. Greaves was the plaintiff Caleb, you said, and where is he from? He's from Georgia, right. What do we know about Arrow? Where are they from? Florida. They're a Florida corporation, right? Florida LLC. What were the underlying facts of the case? In other words, why did Greaves sue Arrow?
Because they misrepresented the car that he sold them.
Right. So, give me some facts behind the transaction that's in question. Who did what?
He contacted someone through their website.
He
Sold it on eBay.
He who?
Greaves.
Right. The plaintiff was shopping for cars on eBay. Right. Okay. Keep going.
They told him to void the warranty, or that he wouldn't need the eBay warranty because he already had one.
So there was some negotiation and exchange of information back and forth. Right. Okay. Then what happened?
I think the case just said that when he got it, he sued them for misrepresenting the facts about it.
How did he get the car?
By mail.
So who sent it?
Arrow.
Arrow sent the car to Greaves in Georgia. Right. So Arrow advertised the car on a website. Greaves saw the listing. He asked questions about it. Arrow answered questions back via email or the messenger function of the eBay website. I think Arrow faxed a contract in to Greaves in Georgia. Is that right? That got signed. Greaves paid. Arrow delivered the car to Greaves in Georgia. He gets it. He's not satisfied. He thinks that there was some fraud and breach of contract that went on in the sales process, and so he sues Arrow in a Georgia court, his home court. Is this a civil case or a criminal case? Civil case. Very good. Bonus question. What will the burden of proof be at trial in a civil case? I don't know that this is in your stuff yet, but we talked about this last week. Preponderance of the evidence, more likely than not. Remember, that's the civil standard. The criminal standard is beyond a reasonable doubt, which is a lot higher. All right, so this is a civil case in the state court system of Georgia, brought by a Georgia resident against a Florida company. So those are the basic facts that we're dealing with. What would you say if you had to sum up in one sentence? What is the question that the Georgia Court of Appeals is having to answer in this case? All right. Should Arrow Toy Store have to come to Georgia? Good. That's right. Whether or not Arrow is subject to jurisdiction in Georgia. I'm saying the same thing you did. You weren't wrong at all. The question is whether or not Arrow Toy Store is subject to jurisdiction in Georgia. Because what's one of the first things that happened in this case as soon as Greaves filed the lawsuit and had it served on Arrow?
They filed to have it dismissed.
Right. Arrow raises their hand and says, "Excuse me, you don't have jurisdiction over me." Remember, the court has to have jurisdiction over the subject matter and of the person or the company. So Arrow says right up front, hold on a second. You don't have jurisdiction over me. I'm not a Georgia resident. I'm not a Georgia corporation. I don't have any offices in Georgia. I don't have employees in Georgia. I'm not licensed to do business in Georgia. I'm not there. I mean, agents in Georgia. So what law would Greaves be using to bring Arrow into a Georgia court? What do we call it? We talked about that Tuesday. The long arm statute. That's right. A long arm statute allows an in-state resident or party to sue an out-of-state resident or corporation so long as they meet certain requirements. That's what we talked about in general on Tuesday. Today, you're looking at the specific Georgia long arm statute. So we're going to see how the court applies that. So skip over to bottom of page 1 of the opinion, trial court decision. I love how the court breaks this up. Very easy to follow. All right, trial court decision. I'm sorry, go on top of page 2 to applicable law. So our long-arm statute would be a law that was passed by who? Congress? No. This is a Georgia statute. Statutes are passed by state legislatures or Congress, but in this case, it'd be the Georgia state legislature. So our state legislatures passed a law codifying what our long-arm statute encompasses. And you'll see in the definition of the long-arm statute what it takes in order to be subject to jurisdiction in Georgia. Let's look at that. Paragraph 1 of the statute authorizes the exercise of personal jurisdiction over a non-resident where they transact any business in this state. That's the wording of the statute. Who is it that's going to decide whether or not the facts of a case constitute transacting business in Georgia? Who decides that? The trial court, that's right. Because that's where they hear the evidence, the facts, the witnesses, the testimony, and all of the things that may support the arguments of either side. Right. Transacts any business in the state. That's the law, but then that's going to be subject to application by the trial court. Paragraph 2 of the long-arm statute provides that Georgia courts can exercise personal jurisdiction over a non-resident who commits a tortious act or omission within the state. A tort is a legal word for a wrong, and so the word tortious would mean wrongful. So now we know that the Georgia statute says if you transact business in this state, you might be subject to long-arm jurisdiction. If you commit a wrong in the state, you might be subject to long-arm jurisdiction. And then the third one is if the non-resident commits a tortious, a wrongful injury in the state caused by an act or omission outside the state. The wrong didn't happen in Georgia, but the tortfeasor, that's the person who did the wrong actor, regularly does or solicits business or engages in any other persistent course of conduct or derives substantial revenue from goods used or consumed or services rendered in the state. That sentence is littered with things that a court would have to interpret, right? An act or omission outside the state. Court would have to determine where the alleged act or omission occurred. Tortfeasor regularly does or solicits business. Court would have to decide what regularly doing or soliciting business would be. Engaging in any other persistent course of conduct. That's for a court to evaluate. Derives substantial revenue. What is substantial? It's going to depend on what the court says. All right, so that's the Georgia long-arm statute. Lays out how a resident could sue a non-resident and the court would have jurisdiction over the non-resident. The court then goes on in the next paragraph to lay out kind of the test that they use to decide if somebody has transacted business. So the appeals courts are giving us some direction about how to interpret the statute. And this would be in the form of case law. Because in future cases, the way that the courts define what test we use would be applicable. So they say that in considering whether a Georgia court could exercise jurisdiction over a non-resident based on the transaction of business. So we're traveling under the first part of the long-arm statute. If the non-resident defendant has purposefully done some act or consummated some transaction in this state, if the cause of action arises from or is connected with such act or transaction, and if the exercise of jurisdiction by the courts of this state does not offend traditional fairness or substantial justice. So I'm not testing y'all on the text of the long arm statute. I don't necessarily need you to know exactly what the Georgia long arm statute says. I just want you to appreciate how it's written, the general gist of it, and then see how the court interprets that in light of past cases, and then how it applies the facts to this case. So when we talk about case law being precedent, all right, the court then is going to review all of the cases where there have been written opinions on this law that are applicable to this case or that are similar to this case. So the court first says that when the minimum contacts rule, when that test first got applied by courts, did the Georgia courts look at long arm jurisdiction broadly or narrowly? Anybody pick up what the court said on that? They said when we started out looking at cases like these, we viewed it very narrowly. In other words, it would take a lot for us to approve long arm jurisdiction over a non-resident defendant. I omitted the years from the cases in this just to save y'all paper and room and make it less complicated. But if you look on the bottom of page 2 where we start on consideration of precedent, the court, it lays out the first case that it's going to discuss as precedent. Cohen Payne Company versus Wood Mosaic. All right. In that case, the court says we had a case where the non-resident did not solicit business in the state, accepted a mail order in another state, and did nothing more than deliver the items here. In that case, the Court of Appeals found that the long arm statute would not apply. Again, I don't have the year in here, so this is many years ago. But they're kind of taking you on a tour of how we have historically looked at long arm jurisdiction. And we started off looking at it very narrowly. It then moves on to talk about this Flint versus Gust and Fears versus Doyne case, top of page 3. The court later held that an out-of-state defendant will not be deemed to have engaged in purposeful business activity merely because he's advertised products for sale in a national magazine that circulates in this state and accepts orders by mail, phone, or other instruments of commerce, da-da-da-da-da. All right, so at first, you were fine if the out-of-state defendant could not be brought here if all they did was fill an order, a mail order. And then we took that a step further and said, even if they advertise here in a national magazine that is circulated through Georgia. This is all probably like foreign language to y'all when we're talking about magazines and things like that. That's how all the advertising used to be. The court is saying we still are going to find that there's no personal jurisdiction over a non-resident, even if they're advertising in things that might make its way to Georgia. So after that, the general rule the court tells you is that mere telephone or mail contact with an out-of-state defendant is not sufficient to establish the purposeful activity that's required for jurisdiction. Would you guess that this criteria or this rationale applied pre-internet or post-internet? Pre. These cases that they're talking about are pre-internet, right? Very much pre-internet. All right, so then we move on, and the court tells you about a case called Mayacamas Corp versus Gulfstream. and in conjunction with a Supreme Court case they call Burger King, United States, Burger King, versus Rudowitz. In those cases, we changed the way courts interpret the minimum contacts a little bit, and those cases would say an individual's contract with an out-of-state party alone cannot establish minimum contacts. If the contract is an intermediate step serving to tie up prior business negotiations. The real thing that the court should be looking at is these other factors, prior negotiations and contemplated future consequences, and that those must be evaluated in determining whether or not it's fair to exercise jurisdiction over the non-resident. Then they go on and they talk about this case of Wise versus State Board of Examination. Placement of merchandise in the stream of commerce for eventual sale to Georgia citizens, along with a warranty/indemnity contract, did amount to transacting business under Georgia. So the court is slowly broadening how they interpret a long-arm statute over time. They're making it more permissive for out-of-state defendants to be sued here. Why do y'all think that is? What do you see happening society-wise and in the life of business, the evolution of business?
There's more interstate commerce.
More interstate commerce, that's right. Much more interstate commerce. We went from a society where there was very little interstate commerce to one where we really don't even distinguish anymore between interstate or out-of-state commerce. We don't even really distinguish that much anymore between domestic commerce and international commerce. There's so much overlap. So that's what you see happening, is that the courts are interpreting these cases or the laws a little bit differently to keep up with the reality of the times. So then we get all the way to the bottom of page 3, this innovative clinical and consulting services versus First National Bank. Actually, skip over that one for a second. If you go toward the bottom of page 4, the court then says, all right, we've looked at all these precedent cases, and we're kind of going to lump them in a couple categories. At one end of the spectrum, you got cases where a defendant clearly does business over the internet. At the other end of the spectrum, you've got a situation where somebody just posts something online, a passive type of activity. And then the middle ground, it says, there's these cases where, yes, somebody passively posts something, but they're also maybe engaging more so than just the passive posting by answering questions, giving information about the products. Just like what Arrow did in this case. Hey, by the way, you don't need that eBay warranty because this car already comes with a longer warranty. Answering questions about the product. So they're not necessarily actively advertising in Georgia, but they're engaging with a consumer in Georgia in a way that's more than just a passive posting. So then the court gets to application of the law to this case. All right, so in this case, we're going to turn back around and say, all right, we know what the statute says. We now have been on a historical tour of how the courts have interpreted the long-arm statute. Now we come to this case. Do we have jurisdiction in Georgia over Arrow based on the facts that Mr. Cochran laid out a little while ago? All right, Ms. Marshall says yes. Why is that?
Because they sent the vehicle to him.
They sent the vehicle here. That was one thing they did, right? What else? Anybody. Warren. They interacted with each other, right? What else? The money was substantial. Although if you're Arrow's lawyer, what do you say to that? What was their argument?
It was just a fraction of their entire revenue.
Right. I would say $31,000 is a pretty good amount in controversy, right? Arrow is saying, well, that was a drop in the bucket of our sales. I don't think that the court compared the percentage of sales as one of their factors, but an interesting sort of nuance to that, for sure. All right, so the underlying idea of all of this is it fair for an out-of-state defendant, in this case Arrow, to have to come to Georgia to defend themselves in this lawsuit? Is that fair? And the court says yes, because by doing business in this state, they are availing themselves, they're taking advantage of, they're using the benefits of Georgia, the customers here, the stream of commerce that goes into Georgia, the reach of eBay Motors internet into Georgia. They're doing business here. And if you're doing business here, it would follow that it's fair for you to be sued here if your actions in those, if the lawsuit concerns you doing that business. That's the underlying rationale for it. And if you think about the evolution of commerce and business and advertising and just the general transmission of information, there was a time when it might not have been fair, or we wouldn't have considered it to be as fair for an out-of-state defendant to have to come here to defend themselves. Travel used to be prohibitive in some ways, especially before the automobile. The cost, the burden on a defendant to have to come here used to be a lot higher than it is. So that's kind of why the fairness evaluation has changed over time too. Not that big a deal for somebody to have to come from Florida to Atlanta to go to court anymore. It's just not. All right, so if you had to sum up in one sentence the holding of the court in this case, the conclusion of the court in this case, what would it be?
They affirmed the trial court's findings.
They did affirm the trial court's findings. They affirmed the trial court's decision that what?
Enough evidence of Arrow involvement in the transaction in Georgia took place for a long statute to.
Good. Good. They affirmed the trial court's ruling that Arrow transacted business in Georgia, had enough minimum contacts with Georgia such that long-arm jurisdiction would apply to them. That's the holding of the case. Excellent. All right, I want you to think for a second about the factors that the court used when they were talking about old cases. The things that they used to look for. Was the ad passive? Was there interaction? Did you just fill a mail order ad? All those things. So put your lawyer hat on now and go back to the beginning of this case, right after it was filed, right after Arrow asked the court to dismiss it for lack of jurisdiction. We're going to start the discovery phase of the case. What are some things that you want to find out about Arrow or about this specific transaction? Anything. It's wide open. It's discovery. What are you going to ask for? All right, say that, Ms. Marshall. I think you said communications between parties. Very good. Why do you want to look for that?
If they
Well, because it looks different if the communications involve bargaining over price or extensive questions about the product, right? Rather than, is the car still available? Yes, good, I'll take it. That's not as in-depth maybe as some of the stuff that went on this case. Good. What else y'all gonna want to know?
How many sales have taken place in Georgia?
Good work. How many sales have taken place in Georgia? Even though the court found that this 1 or 2 was enough, you still want to know that. Because what if Arrow does 50% of their business in Georgia? That's a bad fact for Arrow, right? That makes it a lot easier on the court. So you definitely want to know that. What else y'all want to know?
Previous transactions.
Previous transactions, good. You want to look at how many, the amount, things like that. Maybe to Mr. Wilmot's point, the total amount of business was still a really small percentage, but maybe it was 100 sales last year, and they're a $10 million sales a year corporation. 100 sales looks a lot different. I mean, you don't really care as much then what percentage of revenue it is, do you? 100 sales is doing a lot of business in Georgia. What else do y'all want to know? Get creative, anything. Remember, Discovery's kind of wide open.
Employees.
How many employees you got? Where are they? Do they ever come to Georgia? Have you ever had an office in Georgia? Have you ever been sued in Georgia before? What else?
How many BMWs they sold?
Okay, why would that matter?
To see if any other of the clients have the same issue.
Okay, good.
Communications from the other clients that bought on eBay.
Good. That's an excellent one. Hey, you can't say that you were passive selectively. You just were passive in this case. But in these other cases, look what you did. You had 100 email exchanges with these people. Excellent question. What else?
Transactions from Arrow not used through eBay Motors, maybe through a different,
Oh, that's a great one.
through a different.
He said, and I'll repeat a lot of this for my online people listening, because I don't know if they can hear y'all, but he said transactions or business that they've done through other platforms or other means in Georgia outside of eBay Motors. Very good. Now, would this case have been easier for Greaves to bring against Arrow if Arrow was incorporated in Georgia? Yeah. If you're incorporated in a state, you're subject to jurisdiction there. We don't have to wonder about whether you're transacting business or not. What if Arrow had a office in Georgia? It's easier for Greaves as well, right? Remember, if a corporation is incorporated by the laws of the state, has a place of business there, has an office, then they'll be subject to jurisdiction. This just came up because Arrow happened to not have any of those things in Georgia. Very, very good questions. So that's the nature of the discovery you would want to do. You might want to ask some of those kind of basic questions first through written interrogatories or requests for production of documents. Certainly your ideas about requesting records on other sales and other communications, you'd want to get those kind of up front, maybe before you took anybody's deposition, so that when you do sit down for the deposition, you could ask them about those specific things. Who all might you want to depose in this case? Whose deposition you want to take?
The CEO.
CEO of Arrow. Good.
The agent that the person talked to.
The agent and the person talked to. That's a really good one. What if you find out through Mr. Hare's request about where else you're doing business? You might want to depose salesmen or agents or somebody from the company that sold cars in other states. Very good. All right, anybody have any questions about this case? Yes, sir.
So all of this happened because Creed didn't want to just drive to Florida and Arrow didn't want to just fly to Atlanta.
Right. Greaves did not. That is a great. The question is, all of this happened because Greaves didn't want to go sue them in Florida, and because Arrow didn't want to come to Georgia and defend the case. Yes, but there's more to it than that, I would say. If you're Greaves, put yourself in Greaves' position. Would you rather try your case in front of a jury in Cobb County, where you're from, or in Bay County, where Arrow is?
Yeah, we're not from.
I mean, there's nothing objectively biased about where you are, but there's a perception, isn't it? I'd rather be able to cast this company or this defendant as an out-of-state defendant who is screwing over Georgia consumers. If I'm down in Florida, the lawyer might cast it as, well, it's just some Georgia, person coming down here making trouble for good, upstanding Florida companies. We want to protect our Florida companies. There's nothing in the law that would support a jury or a judge thinking that way. But is it possible? Sure. Lawyers all the time make strategic decisions about which court they choose, if they have a choice, based on the composition of the jury pool. Some jurisdictions have reputations as being really, really friendly to a plaintiff or a defendant. I'll give you a great example, a local example. I got brought in on a products liability case, which I don't really do this. They just brought me in because I knew the judge, which ended up not having any effect on the case, but they liked the appearance of it. So it was in Muskogee County. It was a tractor trailer wreck case. And Muskogee County has a reputation of being much more friendly to the plaintiffs, much more liberal in their decisions, give bigger jury awards than Harris County, which is, if you're not from here, Muskogee is where we are now, Columbus, very diverse, more urban. Harris County is more rural. Anybody from Harris County? We got a Harris County here? All right. I'm not slamming any Harris County people, Mr. Thiel. But Harris County is more rural, very much known as more conservative, less diverse, and much more friendly to defendants. In other words, they don't like people coming into court and asking for, as a general rule, a Harris County citizen isn't going to love the idea of somebody coming to court looking for millions of dollars. That's a way oversimplification, and I don't really, I'm not knocking anybody in Harris County. This is just sort of generally the way people would think. So in this tractor trailer case, they wanted it brought in Muskogee County because one of the defendants was from Muskogee County, but one of them was from Harris County. And the defendants tried to get the case moved to Harris County because they just felt like that would be much more friendly in terms of the jury and the way they'd be received. So those kind of decisions go on all the time. So that's a great question that you asked about that. Arrow would much rather not so much just the travel or the inconvenience of having to travel to Atlanta for this case, but the comfort and the convenience of having a hometown or home state legal system. All right. Any other questions about this case? All right. I am going to ask you about it on the quiz, but I'm not necessarily quizzing you on the letter of the law so much as understanding how the court applied it, how they dealt with precedent, how they came to their decision. Very similar to some of the questions in Brown. While I'm on that real quick, I'm going to go back and add some points to y'all's quizzes for quiz 1. not just this class, but the next class in my online brought up some really good points about how some of the wording I used was confusing. And I'm persuaded that it was confusing and a little bit misleading. So I will be going back and doing that at some point. Hopefully sooner rather than later. All right, look, for those of you who have the content module pulled up on Cougar View, look at week 2, and let's look at for a second. It doesn't want to connect me to the internet. I guess I could do it here. Look at for a second. Oh, my screen died. What's the first discovery example that I've listed there? Sample what?
Deposition.
Sample deposition? All right, pull that up. All right, these are examples of real life discovery. This is nothing exciting here at all, really. But what I want you to see is this illustrates one of the advantages of depositions. You see the question, you see the answer, and then you see the follow-up. Right? Is he married, divorced, separated? He's divorced. Do you know when he was divorced? Do you know when the case started? Have you discussed his divorce with him? Much easier to get information out of somebody in a dialogue type setting where you can follow up on the answers or responses given. I'm trying to... Another important maybe advantage of the deposition over a written interrogatory is a written interrogatory is written one way, right? And the person who's responding might interpret that question in a different way than the asker meant. Look over here at this line 17 on page 23. The question is, and you answered, well, let me go back to line 12. One of the questions was, this is from the interrogatory. So in this case, the lawyer sent interrogatories first. And they asked in the interrogatory, state whether you've had sexual relations with a man other than your husband since your marriage to him. And if so, state the name and address of that person, date of the relations, and place of the sexual relations. And you answered in your interrogatory responses, I did not have sexual relations with another man during my marriage. This was sworn by you in June of whatever year. At that point, you had already had sex with Mr. X. And the answer is yes, All right, well, why didn't you answer that question the way it was asked? Because I filled it out before June. I guess she filled it out before she had sex with Mr. X, but while she was still married. So you see how, I'm not going to get caught up in the details of whatever this affair is. But that is a good illustration to you of how a deposition works. Does it also illustrate to you how absolutely uncomfortable it would be to sit for a deposition? Yeah. In a divorce case anyway, right? Anybody in here married? Nobody's. Does this make you? Would it scare you to get divorced? Not because you've done anything wrong, but just because who wants to have to sit there and answer that, right? That would not be fun. All right, so that is an example of a deposition. This is from a domestic relations case. All right, let's go out of that and pull up the next one, which is a sample complaint. All right, if you remember, a complaint is the document that's filed in court that starts a lawsuit. So in this case, every pleading, which are the things that are filed in a case, is going to have the caption of the case on it at the top every time. It's going to tell you, the very top line, what court are we in? In the state court of Fulton County, state of Georgia. This is in the state court system. It's then going to tell you who the plaintiff is and who the defendant is. And then it'll have a case number. It hadn't been assigned, it looks like, in this case yet, but I have a case number. It has a title telling you that the name of this pleading is the complaint. All right, and so the complaint, remember, lays out the basic facts of the case, what the claim is about, who the parties are. So let's look at how that works as we go through. They're going to lay out for you. Hold on, let me just turn this so I can stay over here. Parties and jurisdiction. Remember, we've got to tell the court who we are and tell the court why they have jurisdiction. Plaintiff was at all times a citizen of the state of Georgia. Defendant, BTW Atlanta, doing business as Buckhead Saloon, is a Georgia corporation whose registered agent is da-da-da-da-da. Buckhead Saloon is a Georgia corporation. So a Georgia court has jurisdiction over a Georgia corporation, right? So we don't have any jurisdictional issues in this case like we did in Greaves. All right, then they're going to go and lay out. You don't have to do it. You don't have to break down your facts, and you do have to break it down somehow. Some people like to break down facts into just one fact per paragraph. That's mostly how you see it. Sometimes it'll be more paragraph in nature. But this is going to tell you what happened. Paragraph 4, on the evening of June 12th, 2017, plaintiff was a customer at the Buckhead Saloon. He was at all times well behaved and paid his bill at the end of the evening. As he was leaving, he bought a bottle of tequila to take home with him, as allowed by law. Paid for it, started to exit the bar. As he exited, without any opportunity to protect himself, defendants who were employees of Buckhead Saloon, looks like beat the hell out of him, including bouncers and maintenance staff. Now, this is just the complaint. The court is not going to be making any rulings based on what he says happened. Buckhead Saloon, as the defendant, is going to file an answer, and they're going to go paragraph by paragraph and say whether they agree or disagree with what's said. I would expect they're going to deny almost all the things that this guy said happened. And then they can add additional paragraphs if there's more that they want to tell the court. So we go through facts that underlie the case. We go through some facts that have to do with agency. Negligence is one of the claims that the plaintiff's asserting. We see assault is one of the claims he's asserting. Battery is one of the claims he's asserting. Intentional infliction of emotional stress is one of the claims. Most of these are all found under tort law, which we're going to study in a couple weeks. Punitive damages. That means he's asking not just for damages to compensate him for his injuries, but he's asking for damages to punish Buckhead Saloon for what they did. Punitive damages are very hard to get. And then page 9 of the complaint is what's known as the prayer. This is where the plaintiff tells the court what they're asking for. So this plaintiff is asking that the defendant be served with process for a trial by jury. See, they've invoked their right to a trial by jury in this case. That plaintiff obtain a judgment against the defendants in a sum in excess of $50,000 to compensate him for his damages. That plaintiff obtain a judgment against defendants for punitive damages in an amount to be decided by a jury, so they don't specify yet what they want there. They want attorney's fees. They want the defendant to pay the expenses of the lawsuit. And then paragraph G, other relief as the court will give them. That's a complaint. That kicks off the lawsuit. All right, move out of that. And pull up the next one, which is sample interrogatories. Remember, interrogatories are just written questions that the other party has to answer in writing under oath. And I told you that interrogatories are really useful to get some basic information before you get started. Things like, list me your bank accounts, or tell me, generally speaking, what all the things are that you say I did wrong, so that I can do some deeper discovery or deeper investigation on those, either by follow-up interrogatories or by depositions. So this is I recognize this as one of my pleadings, and I believe this is a divorce case. So this would be the first thing I would file the case, and I would immediately send these interrogatories. These are general interrogatories that I would send in every divorce case to get me started. So you can flip through and see some of the things that I want to know. What's your name? What's your social? What's your address? What all names have you had? Who you live with? I want to know all the jobs you've had during the last 5 years or during the marriage. Name your employer, dates employed, type of work performed. Why am I asking for those things? What am I going to want to follow up with next? I want to know how much you made. That would be relevant in discussing things like alimony, child support, division of marital assets. Number 5, list the name, address, telephone number of any therapist, counselor, psychologist, or psychiatrist that you've seen since the marriage. When you saw them and why. That feels pretty intrusive, doesn't it? It is. But it's allowable in discovery. Please list what medications you take. List every checking account, da-da-da-da-da-da-da. These are all things that I might want to know up front, because this is the type of information that will be useful for me in litigating the case. One of the purposes of a divorce case is to divide up the assets. So I need to know what you have. If we're going to split them up, we got to know what there is to be split up. Got to know what the pie is before we can cut it up. So that's an example of interrogatories. Sometimes I would get enough from this to know what I was dealing with, and I wouldn't need to take a deposition. But often, based on the responses I get back from this, I'm then going to want to sit down with the other party and conduct an oral deposition where I can have the back and forth questions. All right, let me ask you guys then, does anybody have any questions for me based on what we've talked about this week? All right, I will put up a quiz at some point today, and it will be due Monday night. You have a discussion question this week which if you hadn't looked at it yet is basically ask me any question you want to about the law. And I'll try to answer those as we go throughout the semester. That's all you have for this week. Next week, same format. We're going to start a new topic next week, and then we'll go from there. But if y'all don't have any more questions, then we can be done. And I'll see y'all next week. Have a good weekend. Oh, who came in late?